Hello there, and this is chapter 15, and it's called Environmental Dispute Resolution. Okay, so in the introduction here, your author is talking about how environmental disputes are resolved in real life, and he's making quite a bit of emphasis on the fact that this is not easy to do. He has a very good couple of good lines here at the very beginning. It is costly to clean up dump sites, limit commercial fishing, forego development, and purchase emissions reduction equipment. And this is what I really like. To complicate matters, these efforts benefit many at the expense of a few, and the few have a financial incentive to resist the burden. When the few cry foul, environmental disputes are born. So yeah, that is oftentimes what happens. If the few are organized, the few can make things very difficult indeed at the benefit of the many. The many are not as organized and do not have a specific reason, and the few do. Your author further. Oh, by the way, this is a outline of an oil refinery, and and I'll just repeat that last couple of sentences. To complicate matters, these efforts benefit many at the expense of a few, and the few have a financial incentive to resist the burden. When the few cry foul, environmental disputes are born. So there's lots of ways that disputes rise. What should be done, who should pay for it, who controls the resources, damage, progress. There's lots of things to go over and argue about. There has been some moves for something called alternative dispute resolution, as opposed to litigation, because it is a feeling that litigation awards can be way too large. But as you've learned in some previous chapters, sometimes the litigation awards are large um, to deter action on the part of the polluter if they feel that um, it's even a small chance that you would have a massive award against you. Um, okay, so let's go on to litigation. And litigation is the civilized remedy of last resort for environmental disputes. And in this chapter, we will in particular be talking about litigation in the United States. Now, some famous examples of litigation. There was litigation over the Exxon Valdez oil spill in 1989. In 2009, 20 years after the incident, litigation continued over such things as interest payments on the $507 million in punitive damages. And damages are punitive when they cause pain or provable pain upon the plaintiff. And we'll talk about plaintiffs in a little bit. And then there's the Deepwater Horizon oil spill that generated 90 million pages of documents. There are, this is the next slide here. What is CERCLA? And your book describes CERCLA as the U.S. Comprehensive Environmental Response, Compensation, and Liability Act. It spawned a wave of litigation over liability for hazardous waste cleanup. And your author goes into different examples. Examples here, dumping of toxic waste in Ecuador each day by Texaco. Japanese garbage incinerator near Atsuki Naval Air Force Base, and I would assume that might be Okinawa. And this has spawned a bit of an industry here. There's roughly 25,000 U.S. environmental lawyers that represent all spectrum of the environmental scene, from manufacturers, developers, to companies, municipalities, and federal agencies. And the Superfund is particular fields um, that need to be cleaned up, and money will be allocated from the federal government for that cleanup. Now, the landscape of environmental law, as I've just gone over, there are 25,000 U.S. environmental lawyers. There's lots of different acts: the National Environmental Policy Act, Resource Conservation and Recovery Act, Clean Water Act, Clean Air Act, Toxic Substances Control Act, and CERCLA. CERCLA gave rise to the Superfund Trust Fund used to clean up hazardous waste sites. When the trust fund is used, the EPA attempts to recoup hazardous costs by taking legal action when necessary against past polluters. Okay. Now, what are brownfields and greenfields? Brownfields are abandoned commercial sites that are generally not as dangerous as Superfund sites, but nonetheless make developers wary because of the potential for environmental lawsuits. And greenfields are fields and forests that provide attractive alternative to the potential for costly environmental conflict over brownfields. So, so that is the, shall we say, landscape of litigation and a bit of terms about Superfund and comprehensive environmental law and so forth. We're next going to go into what your author describes as a simple bargaining model. And this model shows some sufficient conditions for settlement. So some, again, basic terminology. The plaintiff, and this is different, for economics class, for me and for you. This is one of my first forays into the legal realm. The plaintiff is the party filing the claim. So he or she who is filing the claim is getting the action underway. But when you file a claim, you have to file it against somebody, and that somebody or organization would be the defendant, and the defendant is the party accused of wrongdoing. Okay. Now, what is the distinction between settlement offers and threat points? Let's see. Settlement offer, or I believe settlement range, is the range that both parties feel the settlement may lie between. It's like any it's like any range in a negotiation. If a plaintiff feels that they're that they are they're going to sue for $100,000, and they think it's going to settle at 50, and the defendant feels that it may settle at, I don't know, 125. Then the settlement range would be between 50 and 125. The threat point is if an offer is done that is beyond what the two parties are willing to settle for, and if so, then the other party is going to say, "I want to go to trial." So if the the plaintiff feels that it's worth 200,000, then the defendant isn't going to settle. And similarly, if the defendant is offering, let's say, $2,000, and then the plaintiff is definitely not going to settle. So, in the world of litigation, there is settlement, in which there's going to be no trial, and a jury and a trial, which the decision is made in court. The threat points are that price or that offer that is made in which the other party is not willing to negotiate and says, okay, if this is where you're going to be, we're going to go to trial. Okay, so other terms are jury awards. Jury awards are what the two parties feel that the jury is going to award this particular case. Are there merits to the case to justify a jury award? And of course, plaintiff and defendant feel that the jury award may feel that the jury awards are different based on looking at the evidence. Attorney fees are what the attorney is going to be making. Settlement range is the range that includes the jury awards and the attorney fees, and the bargaining rent is basically let's see what the bargaining rent is, the amount of money represented by the settlement range. So in a way, the settlement range and the bargaining rent are, for all practical purposes, the same thing. Okay. So these are possible settlement values. This is from your book. And we have the first range here. The expected jury award is the same between plaintiff and defendant. And then you have the range here. And let's say between JD and the defendant's threat point, one can say that is going to be F sub D. And F sub D is going to be the future attorney fees, or the estimation of future attorney fees. The threat point for plaintiff is going to be JP minus FP, and FP is going to be the attorney's fees for the plaintiff. So in the first row, everything is, because the jury awards are the same, you have a settlement range, and if the offer is going to be within this range, it is best for the two parties to settle. But if the offer is greater than the settlement range, the defendant is going to say, "Oh, screw you, screw you, plaintiff. I'm going to go to trial." And same thing for the plaintiff. Plaintiff says, "Oh well, screw you." If the offer is less, plaintiff is going to be better going to trial than settling here. Now that is going to be at an offer that will be less than the settlement range. So let's say the settlement range is between $100,000 and $200,000. Any offer less than $100,000, we're going to trial. Any offer greater than $200,000, we are going to trial. So any offer between $100,000 and $200,000 would be the settlement range. Now, in the next row, we have a different scenario. Your book describes it as the parties have differing expectations for the trial outcome. They're optimistic. So the plaintiff feels that their award is going to be greater than what the defendant thinks it's going to be, and they're both optimistic that the jury is going to award it, and it's going to be different. So JP is greater than JD, and as such, the settlement range is going to be smaller because both sides are confident that they are they're going to get the right and proper jury award, and so there's going to be less room for negotiation. So settlement range is greater. Now the final row here is in which both parties are very entrenched in their position, so much so that JP is greater than the threat point, and so they're very, very confident that they're entrenched in their position. And the same thing with J sub D. So in this case, because JP is greater than TP and JD is less than TD, there is no room for settlement whatsoever, and oh boy, we're going to trial. Now, given my experience in the law, which is not a whole lot, my wife was a paralegal for over 30 years. Lawyers want to settle. Lawyers do not want to go into a trial situation because the loser may get nothing, as we'll find out a little bit later in this chapter, and the winner would get everything. But there's going to be big fees going on and a lot of work, and a jury is a gamble. But it all kind of depends upon what the plaintiff and the defendant ultimately want and whether they are willing to negotiate and compromise. Okay, this ends part 1.